All right.
Yes, Mr. Barber.
Yes, sir. If I approach the registrar, I have informed him a note. Didn't have a chance to review my draft, sir. It could have benefited from a nicety such as "may it please the court" or something like that.
No, that's fine. This is fine. Mr. Parnell, when you're finished, I'll ask you to make a comment on this.
Well, I'm grateful to Mr. Bowden for producing this draft, which I saw about 1 minute before you did. We don't have any comments, I don't think, in relation to items 1 and 2. Item 3, unfortunately, I think, identifies precisely the issue which I touched upon immediately before the short adjournment. If I could perhaps start with item Roman 3 in part 3, because it encapsulates the problem. This is tantamount to an order for standard disclosure. This is going to be a very significant exercise indeed. It may or may not be appreciated by the appellant that the acquisition of the Limestone House properties was a significant transaction. It was price sensitive for a number of reasons. It was highly commercially sensitive. There is going to need to be a very significant exercise to identify which aspects of the documents, which I believe were at least in part held in the data room, pertain to Unit 17A and 17B. There is going to need to be an exercise to work out what steps, if any, need to be taken to ensure that there are no breaches of any warranties given as in relation to the transaction as between Emirates and UP. There is then going to need to be a significant exercise to identify what, if anything, needs to be redacted from those documents. It is understood that there are price-sensitive aspects of these documents which my clients and no doubt UP would not like to be in the public domain. That is in the face of an order for security for costs, which is, for these purposes, being waived to permit these documents to be disclosed. The point which His Honour Sir Jeremy Cook made before lunch, which is that were we to be looking at, in I think your exact words, my Lord, were 2 or 3 documents, that would not be that would not be an issue. And as I said,
well, let me ask you this: just looking at, if you had 1 and 2, but not 3, 4, and 5, would that be a much more defined and perhaps even limited as to a period of time, so that?
Not for the first time today, you've actually anticipated my exact point. 1 and 2, and yes, I think time limited, because there will either be a few brief exchanges or nothing at all. It's going to be one or the other.
And those are documents which cross the line, which are obviously of much more significance in the context of the argument that's being put, rather than simply internal documents. Which amount to no more than the sort of the amount of notice you've got, so to speak, of the actions in question.
Yes, I don't think 1 or 2 would cause any great difficulties. I mean, I can go into why 4 and 5 are objectionable, simply because the concern, and it's a real concern, is that we do not want the order for security for costs to be rendered meaningless, and we don't see why we should be put in that position, to be brutally frank.
I wasn't sure whether you're objecting to 3 and 4, or 4 and 5, or all 3.
I'm objecting to 3, 4, and 5.
I don't even understand what 5 is, actually.
Well, that was our first reason for objecting to it. We don't understand.
Object to something you don't understand.
I'm afraid this may come across as a slightly juvenile position. We objected to it because we didn't understand it. If we did understand it, we think we'd probably object to it anyway. but we don't. It doesn't seem to us that we don't really know what 5 is meant to address.
But let me ask you this: in relation to 3, there is a document called a due diligence report. Is there?
No, the due diligence exercise, as we understand it, took place over a lengthy period of time.
It's likely to consist of one major report, probably, and a whole lot of additional letters, is it?
I mean,
Is that your
somebody,
understanding?
yeah.
I genuinely don't know. It may do. That would be the conventional way of approaching it, but I don't know at this stage.
The data room is for the foot soldiers to go and make their searches. They then compile a report for the seniors, who actually have to make the decisions. So, no, I just want to know whether there is a due diligence report at the end of the day. And then, what is you don't think you understand 5? Mr. Bowden, can you explain 5 to us?
Yes, sir. If one looks at the timing of the banking of these cheques, so the offer to sell was made on the 26th of December 2011. The counter offer came through, 18 December. The counter offer came through on the 18th. The transaction, the master sales agreement, was clearly entered into, I think, in January 2012. There was the offer and counter offer anticipated that a lot of work would be done, so there'd be a timeline for the completion of the transaction. Months after that, sir, that these cheques are banked on the 28th of August and the 1st of September. Indeed, months after the letter dated the 30th of April, where they purport to rescind, if that's the right word, the contract. There may be a little bit.
Who tried to rescind what contract?
I'm talking about the letter dated 30 April 2012, sir, where the bank said, we don't know anything about this lease. It's got nothing to do with us. Your Honour pointed the letter out to me earlier this morning. The 30 April letter.
From Taylor Wessing?
No, from the bank.
To whom? To UP?
To UP, sir, yes. Dated 30 April, and it can be found at tab 21, volume 2.
Sorry, what's that got to do with 5?
The timing of the banking of the cheques, it's my view or suspicion that in fact what happened with the banking of these cheques is that given that the landlord was in fact a bank or a division, property division of a bank, and my client banked with that bank, but they simply looked in his bank account, saw that there was no money in there, in that particular bank account, decided to bank the cheques. That's my expectation of how this all unfolded. Doing so because the next thing that happened is they told him, well, your cheques are bounced, so we don't have any contract with you.
Well, first of all, I don't even understand what you are actually asking for. A printout of all queries to and views of the appellant's bank account. How do you query a bank account? You query a person or an institution.
I mean a computer-driven query. So that the bank officer goes to the terminal, types in the bank account details of the appellant company and looks. And that leaves a trail.
I'm sorry, are you saying that there is no law of banking secrecy here? The fact that this is a property company and it's related to a bank doesn't entitle it to go and query the bank's customers' accounts.
It's a matter that I'm pretty interested in, sir.
I'm sorry?
It is certainly a matter that occurred to me as an explanation for why those cheques were banked when they were.
But it doesn't.
It's their own account they want to look at. I don't understand what he's hoping to get at.
But I don't see how that bears on the issue of why. You know, generally speaking, in contract law cases, let's start with the assumption it's a contract law case. What matters is what was done, not why was it done. Inequity may be, but you know, we're a step away from mounting the staircase on that approach for the moment.
It may have been a little opportunistic of me to put that in there now, sir, but I was planning to do it at some stage, and it did.
I mean, you have some evidence that the cheques were banked in. You can make something of that, but...
I'm happy to give way on 5, sir.
And 3 and 4?
Well, 4, sir, I think we do know sufficiently from the documents that we've got now what happened. It was drawn, well, the cheques were banked and there wasn't any money.
It's the same thrust as question 5, isn't it?
4 was a bit of a belts and braces, sir, but I don't know what else was done or said about it. Okay.
What's the best you could hope for? What is the best you could hope for if you had these documents? What might they show that would assist you?
You see,
well, the reason why they did it at that point in time.
Let's see, Mr. Bowden.
It comes back to the Chief Justice.
You know, in order to make any kind of case, either based on contract or equity, what you have to show is there were some acts taken by the respondent which involve some form of communication to your client or an act that involved dealing with your client's property, you know, namely the monies in some way.
Yes.
And it really doesn't matter why they did it. The onus is on them, because once they start dealing with rental checks, then you may have some kind of, you can mount some kind of an argument. You are assuming the function of a landlord vis-a-vis me. And you know that now, and you know all you need to do is to lay that out, and then the evidential burden shifts to a certain extent to the other side. They can come and give an explanation, but if they don't, then you know it stands out there. Why are you banking in my checks if you say that A, you don't know who I am, and B, you don't know that I have a tenancy, and C, you refuse to accept me anyway? Right? So you can ask those questions in the light of apparently what evidence that you have. So 4 and 5 might go together, and 3 has some practical and logistical difficulties about redactions, confidentiality, and maybe you're asking for too much because you're only talking about 2 units and go and do a lot of work.
There's a good point there, sir. This confidentiality and redaction business has been vastly overstated by my learned friend, and that could be found at Volume 1, Tab 14. And that is this is the letter that was attached to the Wessing letter of 9 August 2016. It sets out here, down
I'm sorry, give the tab number again, please.
14, sir, page
14 of volume 1?
Volume 2, my apologies, I sent you to the wrong one.
Volume 2, yes. Which letter?
Yes, it's page 123, sir.
Yes.
Volume 2, page 123. The table there, sir. This is the document that came from my learned friend. There's no redaction there, sir. It tells us that the value of the transaction was 1 billion dirhams.
So?
Well, how could he possibly complain about the need to maintain financial details, confidentiality, when he's already provided that level of details? And I would add that it's not a matter that concerns us in the slightest. We're not interested in the price that they paid. It's relevant to our queries, and if he wants to redact any of that information, well, he's welcome to do so. The point is, though, sir, and I may take a moment to find it, but in the evidence of Mr. Al-Khalili in support, it must be in witness statements 4 and 5, sir, what he says is that he understands that, going by my memory, not the documents, sir, but that there was a due diligence exercise. And it comes exactly back to the point that Omar was making this morning, sir, and that is that there must be, so extension of the vegetable barrow point, there must be some evidence of what they did to satisfy themselves. And indeed, sir, the letters under 15 and 16 anticipate that there will be an exchange of documentation, because if we go to tab 16, sir, that UP agrees that the actual handover be for a period of 5 days. Purchase price is there. And UP agrees to the following: execute sale and purchase complete within 1 month. Transfer all of the title deeds.
Are we reading from page 127?
120. I'm on 128 now, sir.
Yes.
So that there was a clear process set out under 5, 6, 7 of that letter that there will be some form of due diligence. And I understand, sir, that there was.
Why do you say that?
And
why do you say that this implies that there would be due diligence?
Well,
it's just an obligation, a contractual obligation undertaken by the vendor.
Yes, but if we come to 7, and sorry, I may have to go back to the slightly earlier, to the offer letter, sir.
You're back to 123.
I may have to retreat to the position, sir, that it must have been done. The commercial reality, sir, is that it was done. I don't want to give evidence from the bar, sir, but my understanding that it was done.
My lord, if I may assist, there isn't.
Quite hear you. You better speak up.
There isn't an issue as to whether it was done. The issue is as to whether, at this point in time, Mr. Bowden is entitled to seek disclosure of these documents, and we say for the reasons that we've just given. And I accept that my state of knowledge about exactly what was done and exactly what documents exist is very far from perfect. I make no bones about that. But taking on board the point that I made immediately before lunch, and to which Sir Jeremy Cook responded, the plain fact is that this would be, in effect, a concession to the existing security for costs order. If Mr. Bowden complies with the security for costs order, then we're into an entirely different line of country. At that point, no doubt directions for standard disclosure will follow, and contrary to what Mr. Bowden has suggested in his skeleton, that will be observed. But it would really be most unfair indeed were the security for costs order to be rendered nugatory in this way. And I appreciate everything that you said this morning about putting cards on the table, but similarly, that goes both ways.
Whilst my learned friend interrupted me, but it did give me the opportunity to find the document I was flailing around for, and that is Sir, Volume 1, page 101. Tab 18, Sir. At the top. I'm informed that there was an extensive due diligence process undertaken by the respondent, and this was headed by the employee of the respondent, Melanie Fernandez. That's significant to me, as it was Ms Fernandez who authored the letter to the Registrar of Companies giving permission for the issue of the trade licence. So we are saying, sir, that all of this is linked, that there was a due diligence. The person who actually knew about it and who had done the due diligence later wrote a letter that we can't find off to the Registrar of Companies. Following that, there was this slightly strange, I agree, slightly irregular instruction to the appellant that it should register the lease, which it then attempted to do so. So it's all linked in, sir. Only relates to 2 units. We're not interested in anything other than the 2 units. But on a certain day, somebody must have ticked some boxes, presumably on a form, said units LP6 or 17A, has it got a lease? Yes. We measured the size of it? Yes. We checked if there's anyone in occupation there? Yes. That's really all that's required. And I think it's vastly overstating it to say that this is going to be a huge exercise. We do these things all day, every day, all of us, looking in boxes and computers, sometimes getting backups of things returned to us. So
If on the Emirates side they were represented by lawyers, do we know if UP were represented by lawyers?
Yes, just from a previous discussion with Ms. Odru, I'm sure they were, yes.
I mean, it isn't, well, I mean, a shorter route which wouldn't require a lot of effort is simply to ask for the correspondence between the lawyers. Because, look, I used to do conveyancing, okay? I used to do transactions like this. So I know what you have to do when you buy over a building with a lot of sitting tenants. I mean, the first thing you do is you decide whether the sale, well, usually you have to take the tenants as you find them, right? And the next thing you do is the buyer's lawyer will say, you've disclosed so many leases, let us have copies of the leases. And when it's 25, you probably sit down in a room and go through them together and ask questions of them at the same time. Now, these are all the sort of things that normal transactional lawyers will do. You know what they do, and these would not be confidential in that respect, so they would just be exchanged openly between the lawyers or anybody, even the clients themselves asking for those documents. But I think we've come to the conclusion that at this stage, given where we are, we will only allow you 1 and 2, and then we'll save 3, 4, and 5 for a later stage. As Mr. Kani is saying, that at this point, you are already getting a dispensation from the existing stay order. And when it comes to the order itself, I think actually we need to make an order that technically we have lifted the stay to allow, in fact, even this application to be made. And to the extent that the orders are made from this court, they will continue to be a part of that exception. But thereafter, you don't do anything until you've got these documents from the 2 registrars and under items 1 and 2. Then you look at it, then you decide in your next step. Either you decide that, well, these documents show now that we don't have a case, in which case you negotiate to terminate the case, or you think that you are given fresh hope, in which case you will have to tell your client to beg, borrow, or steal the amount of security required, which is actually in absolute terms not huge. When we consider that presumably your client still thinks that this is, or at least was, a potentially quite profitable venture. He was prepared to commit himself for 10 years to a 30,000 square foot property in prime commercial location. What I would suggest, and this is not for today, but at a later on, is when you've got this minimal quantity of documentation, which Mr. Carnell is prepared to concede is not going to involve a lot of effort and costs on the part of his clients. Going forward, in my view, it's a better use of your forensic resources if you approach the question of disclosure of documents by first trying to find out from the other party what documents actually exist before you request for them. The whole way in which the process of document production has evolved has been, in my view, a little bit corrupted by the way that the IBA rules have functioned. And we have this all the time in arbitration, and I am constantly exhorting people, don't stretch the request to the extent that unreasonable burdens are put on the requested party to go and hunt, and on the other hand also the requested party is allowed by the vagueness of the query to actually deflect or finesse the request by some answer which tells you nothing, like we have no documents responsive to your request, and you don't know what they mean. or different people can have different interpretations of that phrase. So, what you want to be doing is thinking, if and when this particular witness came to the court, what questions would I be asking him? And then you would be asking him a series of questions like, did you do due diligence? What due diligence did you conduct? What was your specific inquiries into these units? And so on. So you build up, which they have to answer if we permit it. You come and get leave from the court, and the court will say, well, are these all legitimate questions that you could ask on cross? If you can ask them on cross, then there's no reason why you can't ask them in advance of the hearing, so that if the answers prove to be correct and identify certain documents, then you zone in on that document or class of documents, and then so that you don't actually have to wait until the hearing and then get an answer that a document actually exists but hasn't been disclosed until that very late stage, and then you have to adjourn the hearing to go and find the document. But that's further down the line. So for now, neither of you had anything more to say. We will in principle grant orders under this written request which you have submitted. This informal note to the Court of Appeal dated March the 6th of 2017.
Should I tidy it up so we put it in the form of a draft order?
Exactly. If you can put a draft order in terms of 1, 2, and 3A, little 1, little 2, do we need B and C? Because he provides a verified list of the following documents. I suppose B and C actually follow as a matter of course, that we assume that they have been or are in their possession unless they say otherwise. But if you want to have B and C, I'm sure Mr. Carnell wouldn't have strong objections to that.
No strong objections.
Okay, so let's do it on that basis. 1A and B, 2A and B, 3A, little 1, little 2, 3B, 3C. Okay, we'll grant an order in terms of that. And then we have to couple it or add to it an order that the stay, the current stay, is lifted for the purposes of allowing this application to be heard and for the following orders to be carried out and no further.
We had consented to the stay, so no difficulty.
And then, of course, you've got to include the orders about the subpoena and so. Oh well, sorry, it's already been included. So this covers the entire range of orders then that you want from today. Okay. What should we do about costs? We reserve the costs. I think we should reserve. So we reserve the costs. We don't make an order for costs today. We reserve it. The costs of today will be reserved. Is there anything else that either of you want to say, housekeeping wise?
Just one housekeeping thought, my lord. The background to this order, of course, was that the parties should, as it were, go and have a long, hard think about their respective cases. I'm all in favour of long, hard thinking, but should it be time limited? In the sense that the parties should perhaps restore the original application for directions at a point X weeks hence. I'm just concerned that this case doesn't drag on into the distant future.
We will give liberty to apply. So if you think that it's been an unreasonable length of time after all the documents have been produced to the other side, then you can say, what do you intend to do? If you don't tell us, then we will ask for it to be restored. And I think what we would like to do is to keep track of this ourselves at the court level. And when you come back and you ask for directions or further case management conference, I would administratively ask Judge Omar Muhairi to take charge of the case management conferences from now on, but in his capacity as a CFI judge.
Yes.
Right? So that then there's continuity. He knows exactly the circumstances under which these events are.
I'm sure that will be immensely beneficial, my lord.
Yeah. Okay, if there's nothing else, just one last housekeeping matter, Mr. Carnell. I just want something for your edification. We've had this dispute about whether or not your affidavit was or was not in compliance with Practice Direction number 1 of last year. I have to tell you that it was not in compliance with that Practice Direction. It was specifically aimed at this situation occurring. Yours is sort of right within the four corners of the Practice Direction, because sometimes there's a little bit of remote application because you have a firm which gets one of the juniors to file an affidavit and then the senior argues it. So there's a little bit of separation. Here, you are the one filing the affidavit. You are the one arguing the case. So there are two reasons why you shouldn't do that. One is for the benefit of the court because you imperil your independence. And really, you don't have any evidential value. And I emphasize the word evidential because you explained it as being something which actually is all there in the documents. Well, if it's all there in the documents, then your job is not to be a witness, your job is to be an advocate. Your job in explaining your client's case should be as advocate and not as witness. Another reason why you shouldn't do it is that you give the court the impression that you might actually be wanting to shield your client from having to make a witness statement and raising certain doubts in the mind of the court that you do not want to commit to your client to saying something effectively on oath because he has to swear to the truth of it. And particularly in this case where there are certain very unequivocal statements have been made in the correspondence. If he were to repeat, your client's representative were to repeat those in a witness statement and subsequently it turns out that that's not correct, then of course the evidential impact of that is much greater than if it was simply made by counsel and counsel say, well, that was my instruction and I didn't realize something or other. Particularly as in this particular case, you've told us yourself quite candidly that there are several matters, aspects of the evidential parts of the case that you have not yet got into. The other reason, frankly, is also for your own protection because you also do not want to be swearing to the truth of documents based on instructions because you take on yourself that responsibility of having verified to the best of your information and belief that what you were told by your client is true. So, as a piece of evidence, if it mattered, which it does not in this particular case, your witness statement would have, in my view, zero evidential value. On the other hand, I can look at it and accept it for what it is, which is basically a submission on behalf of your client. And once you read it that way, then obviously it has a certain value. So it should be in its correct categorization. And if to the extent that you needed any actual verification of relevant and critical facts, that should have been done by a person with personal knowledge. Okay?
I'm obliged, my lord.
Thank you. Does anyone else have any...
With sine die, sir? The German sine die or...
Well, the stay exists, and the stay is in its normal form. And I don't think there's anything specific in the rules, but in most courts, if the stay goes on beyond a certain period, then the party in whose favor the stay is operating may come back and ask for the claim to be struck out, on the grounds of want of prosecution. So that is, if you like, the stay is not sine die. The stay is indefinite, yes. So by use of the term, it is indefinite. But I'm specifically adding a liberty to apply. So either party can say, right, I now want to have the stay formally lifted, or the other side may say, I want you to put up or shut up.
This appeal then is moot. This appeal is finished or adjourned?
This appeal is, I think for the moment, I think it actually has dealt with all of the matters. If you start again, it'll go back down to case management and then come up again if it has to, right? What is security?
That's being reviewed. So true. Has to come back here for security costs. If that's going to be isn't resolved between the parties, it'll have to come back here. There's nowhere else to go.
Allowed in parts and the security for costs adjourned.
Security for costs will have to be adjourned because it'll have to come back here if you haven't reached agreement or satisfied.
I mean, eventually you may dispose of it, at the CFI level between yourselves. You provide the security, or maybe the amount will be agreed to be to a different level. I don't know what. But that is simply, it's an interlocutory order, so things can change at the CFI level. But technically, you are correct. The appeal remains adjourned indefinitely, because the stay continues to exist, and it's only lifted for this limited purpose as spelled out in this order. Otherwise, you just then the door is shut again. Neither side can move on it, but either side can resurrect it when it's ready.
Grateful, thank you, sir.
I'm just saying this, I can't be the only person here who thinks that there's a third party involved in this who ought to be involved in any discussions that might take place with a view to sorting out an amicable solution.
The legal manager did mention to me as she left that she found the day most illuminating. So.
Yes, well, let's hope it is more than illuminating.
Thank you, sir.
Right. Thank you.
All rise.
Okay. Cheerio.
Thanks. Thanks, James. Good clean fight.
Yeah, but without any particular punches being landed.